दोस्तों इस क्लास में आपको डिक्टेशन दूंगा मैं 100 WPM पर 600 वर्ड्स की डिक्टेशन है, आपको डिक्टेशन में प्रोवाइड कर रहा हूं। बी रेडी फॉर इट। The present criminal appeal, which has been heard through video conferencing, is at the instance of Muhammad Anwar, who impugns the judgment of the High Court of Delhi, whereby his appeal against a judgment of the Additional Sessions Judge convicting and sentencing him under Section 394 of the Indian Penal Code 1860 and Section 25 of the Arms Act 1959 was turned down. The case of the prosecution is that the victim complainant was riding his motorcycle on the main road near Shahadra when he stopped to ease himself near a fish pond. Suddenly, three boys, including the appellant, caught hold of him and started assaulting him. They were armed with a knife and revolver. Upon extortion, the complainant handed over a bundle of 500 rupees notes totaling around 30,000 to the boys, who then contemplated murdering him by stabbing so that he would not report the matter to the police. Hearing commotion of passers-by, the three boys left the complainant and ran towards a warehouse. The complainant then returned to his home and reported the matter to the jurisdictional police the following evening. This complainant was subsequently converted into an FIR. A police party, during routine checking of buses near GT Road, noticed three boys surreptitiously deboarding a bus through the rear door. On suspicion, Constable Vinod Kumar and Constable Prakash Chand chased and apprehended them and recovered a prohibited knife from the appellant and his co-accused. They also confessed to having robbed the present complainant. All three were arrested and produced before the Metropolitan Magistrate for a test identification parade the following day, which they refused to undergo. The prosecution examined 12 witnesses during trial, which included the victim complainant, the Metropolitan Magistrate who sought to conduct the test identification parade proceedings, and a total of 10 policemen. Sketches of the knife, arrest memos, site plans, and recovered money and weapons were admitted in evidence. The appellant and his co-accused plainly denied the allegations and claimed that the case was planted by the police upon their failure to pay a bribe of rupees 25,000. They, however, led no evidence in defense. The trial court discarded the defense plea for want of supporting material and further found the likelihood of false implication being remote. All 12 prosecution witnesses were noted to have withstood cross-examination and their testimonies were designated as being stellar. The trial court explained the absence of any public witness as being nothing abnormal given the circumstances of the case. The unreasoned refusal of the accused to take part in the test identification parade proceedings was found to be highly incriminating and substantiating their guilt. The trial court thus held all three accused guilty of robbery with attempt to cause grievous hurt and sentenced them to 7 years rigorous imprisonment under Section 397 of IPC, 5 years rigorous imprisonment under Section 392 of IPC, 2 years rigorous imprisonment under Section 25 of the Arms Act, and fine of rupees 5,000. the appellant approached the High Court, which dismissed the charge under Section 397 of IPC and instead convicted him under Section 394 with a reduced sentence of only 2 years rigorous imprisonment. Another co-accused, Muhammad Aslam, was acquitted on charges of robbery as the version of the complainant qua him was found doubtful. The High Court noted that although as per the FIR, 3 unidentified persons had robbed the victim, as far as the present appellant was concerned, the High Court specifically noted that no animosity or motive for false implication had been proffered by him and that there were no contradictions in the testimonies of the witnesses as regards his role in the crime. दोस्तों इसी के साथ ये डिक्टेशन फिनिश होती है। पूरी उम्मीद है आप लोगों ने इसे अच्छे से लिखा होगा। इजी डिक्टेशन नहीं है, अच्छे वर्ड्स इसमें आए हैं, तो आप मुझे कमेंट सेक्शन में ज़रूर बताइएगा कितनी मिस्टेक्स आपकी इसमें आई हैं। 120 WPM की डिक्टेशन प्रोवाइड की जा चुकी है, तो आप वहाँ से भी इसे लिख सकते हैं अगर 120 पे लिखना चाहते हैं तो। स्पीड इंक्रीज़ करके जो इसमें यूट्यूब का एक फ़ीचर है, उसमें एक बहुत बड़ी समस्या क्या है कि आप उसमें स्पीड जो स्लो होती है उसमें जो बीच के गैप है वो गैप नहीं होता, उसमें वर्ड को फास्ट कर दिया जाता है। तो इस वजह से कोई भी डिक्टेशन रिकॉर्ड भी अगर हम करते हैं तो रिकॉर्ड अलग अलग ही करनी होती है। ऐसा नहीं कर सकते कि उस डिक्टेशन को बस थोड़ा स्पीड उसकी मतलब मल्टीप्लाई 1 किया तो उसकी स्पीड बढ़ जाएगी। ऐसा इसलिए नहीं होता क्योंकि डिक्टेशंस में रेगुलर पॉजेस देना, 2 वर्ड्स के 3 वर्ड्स के बीच में पॉज देना, फुल स्टॉप पे पॉज देना, वो बहुत ज़्यादा ज़रूरी है। लेकिन जब आप स्पीड को सॉफ्टवेयर के थ्रू बढ़ाते हैं तो वहाँ पर वो पॉजेज़ ना बढ़ने की बजाय वर्ड को जल्दी जल्दी बोल दिया जाता है। इस वजह से मैं प्रेफर करता हूँ कि पूरी डिक्टेशंस आपको प्रोवाइड की जाए। तो दोस्तों आप मेहनत कीजिए, कमेंट सेक्शन में बताइए कितनी मिस्टेक्स आपकी शॉर्टहैंड में आई हैं और मेहनत करते रहिए। आपसे मुलाकात करूँगा अगली क्लास में अगली ट्रांसक्रिप्शन के साथ। तब तक के लिए बाय बाय, टेक केयर।